It is the retrial of Karen Read, day 14. It's Monday, May 12th. And yes, we are going to be resuming trial with the continued and extended cross-examination of Sergeant Yuri Bukhenik. Why? Well, because the defense isn't done yet, and the defense can cross-examine as long as they need to, so long as they are still getting into new areas of cross-examination. They cannot repasturate the exact same ground over and over and over again. That becomes asked and answered. But if there are new areas of cross to get into, they can still do that. And there are some areas of cross that we know they haven't gotten into yet. So another morning of cross.
But there is evidence that someone had accessed the account through John O'Keefe's cell phone, correct?
I am not aware of that.
Are you aware
What?
that
How are you not aware?
John O'Keefe's cell phone was recovered by Massachusetts State Police, someone at Massachusetts State Police actually opened the Ring app on his cell phone?
Yes.
Who is the person who opened and accessed the Ring app on John O'Keefe's cell phone?
I'm not 100% sure.
May I approach, Your Honor?
Yes.
Sergeant, having looked at this report, does that refresh your recollection as to who may have accessed that Ring app?
Yes, that report is authored by Michael Proctor, and it says that investigators accessed the Ring application.
Thank you. Is that a photograph that was sent by Trooper DeChico?
For everyone who wanted to know what the photo was, I don't think we saw this last time. The big story, David Yannetti, criminal defense attorney.
To the group.
According to this document, yes.
Who is depicted in that photograph?
The big story, Mr. David Yannetti, criminal defense attorney.
Do you see that person in court?
Yes, I do.
Where is he seated and what is he wearing?
He's seated right there wearing a blue tie and
I don't remember this from last time at all.
dark suit, white shirt.
Thank you. We could bring the lights up.
And Mr. Yannetti is just like, thanks y'all for using a good photo.
And he responded to the group, funny,
Oh boy.
I'm going through his client's phone, correct?
That's what it says, yes.
Michael Proctor then responded again.
How many times is Jackson going to say that?
Is that right?
Yes.
He wrote, no nudes so far, correct?
That's what it says, yes.
Michael Proctor responded yet again. Is that right?
That's correct.
And in reference to Mr. Yannetti's photograph, he wrote, I hate that man. I truly hate him. Correct?
That's what it says.
On October 15th, 2022, you completed a performance review of Michael Proctor, correct?
That's correct.
Sir,
Specifically,
you're sitting here representing the
You were
Massachusetts
asked
State Police.
to rank his, quote, oral and written communication skills, end quote, correct?
Correct.
That's part of an overall evaluation and performance review. Is that right?
Yes, overall 90-day quarterly annual review.
You were specifically asked to rank
Oh boy.
whether he effectively would whether members, your subordinates, would effectively communicate with others, both within and outside the department, in oral and written form, correct?
That's correct.
And you rated him as exceptional, a number 4 rating out of 5, correct?
That's correct.
You actually went on to write and comment on Michael Proctor, and you wrote,
I want to know
quote,
the date
Trooper
of this.
Michael Proctor displays professional demeanor, composure, dignity, and respect during the performance of his duties, and especially during his interactions with the public.
What date is that
This is
from?
seen during interviews with witnesses, suspects, as well as victims and their families, end quote. That was a statement you wrote about Michael Proctor, correct?
Good use of performance
correct.
exam.
And
He
this
said
is
the date.
after
Thank you, Chad.
the
October
text
15th.
chain that we've just been talking about,
Thank
where
you.
he calls Miss Read and references looking for nude photographs of her, correct?
That is correct.
Did it show integrity in your view when your subordinate Michael Proctor called Miss Read?
Objection. I'll allow that one.
I didn't read that
I
text.
believe that as a U.S. citizen, he has the right to comment. That's his First Amendment right.
It's a work group text. I didn't have the First Amendment on my bingo card. Maybe I should have. It's a work text. There are restrictions in how you comport yourself at work.
I believe that as a U.S. citizen, he has the right to comment. That's his First Amendment right. We uphold the Constitution, and it's unfortunate, unprofessional what he said in the private text message communication. He might have been voicing his frustrations. I cannot speak for Michael Proctor. It is unprofessional and unfortunate that he said that.
This was not, Sergeant Buchanan, a private text message conversation. This was with his boss and 4 or 5 other individuals, one of whom was your boss.
Like the bossy boss.
Correct.
Who says that shit in front of like the bossy boss? It just goes to the culture because they're real comfortable.
Correct.
This was a communication intended for and received by members of his unit in furtherance of his investigative authority, correct?
It was amongst members of the unit.
He was updating his boss about what he was doing in furtherance of the investigation, going through her phone, correct?
No, I would disagree with you on that. This was a group chain, text message chain that we were discussing private matters in our personal lives.
Private matters, including going through Miss Reed's phone?
That is unfortunately shared on that group text.
So in other words,
Should have been on a different group text.
to the public, he holds one face in private conversations with you and your colleagues within the unit. He shows a completely different face, private face, correct? Objection.
It's day 14, and the cross-examination has covered a lot of different areas this morning with Alan Jackson and Sergeant Buchanan. We have not gotten into the Sallyport videos of Karen Read's SUV arriving. But at the very beginning of the day, we heard that the Commonwealth has filed additional motions. The court is going to take those up at some point. And then we started into the cross-examination. And when the jury was excused for lunch, the court took the time to do, or allow the defense to do, a voir dire of Sergeant Buchanan in a few different areas to determine whether or not he had personal knowledge of those areas, which is a requisite for witnesses to testify about information, depending on what the information is. They have to have personal knowledge of the facts of that information. As we got into it, that voir dire was regarding a line of questioning that had been cut short earlier in cross-examination regarding Proctor's relationship with Chris and Julie Albert, and text messages Proctor and his sister were talking back and forth on, conversations between Proctor's wife, I think, and Julie Albert, because they went back and forth between names and whether it was the wife or the sister. It got much more clear once we got to the wife or the sister, and text messages about Julie Albert and the relationship. What Sergeant Buchanan said that he was aware of is that Trooper Proctor told him when they went to go interview Chris and Julie Albert that he knew them from like being a parent in the community, but wasn't really friendly with them. Now, we know from the first trial that that is a substantial downplaying of that relationship. The issue here is evidence-wise that Sergeant Buchanan did not know that. He knew what was told to him by Trooper Proctor the day they went to do that interview in February 2022, and he knew some of what he's learned since, but he has not been presented things in person. So the court is not going to allow a further questioning into the area of the relationship between Proctor and the Alberts to Sergeant Buchanan's knowledge, because he says he does not have knowledge of those things. He heard some of the information, but it was not part of his investigation. It's not something he looked into. I wish Alan Jackson would have asked him that, because he said he needed to look into it. I wish we would have heard about, well, did you look into this more? Did you try to determine what Proctor had told you, not told you? But that was not asked on voir dire. What was asked about was what information he was aware of from the federal dump is what they're calling it, of information. What he was aware of from text messages, he's not on those text message chains. So that information is going to have to come in through a different witness, probably Trooper Proctor or his sister or his wife. Can the defense call any of those witnesses if they want to? Yes, they can. Can the prosecution call those witnesses if they want to? Yes, they can, but they probably won't. So we will see what happens, because the prosecution, I think, is in a real interesting spot with deciding if they call Proctor or not. We then got into, during cross-examination, video that we had not seen before because it was not turned over prior to the first trial, of Brian Higgins' movements around and about Canton PD in the early morning, after 1 a.m. to after 1:45 a.m. when he finally leaves. And you see video of presumed to be Brian Higgins pulling in Brian Higgins's Jeep with the plow on it, parking, going into Canton PD, going into an office, going down the hallway, back out into the parking lot, going and moving a car, then at the Jeep, then at a car next to his Jeep, then at a car across from that car, back and forth to all these different cars, getting things out of a truck, in and around different truck doors, and all these cars are just unlocked. And he is undertaking quite a lot of activity in and around these unlocked cars. Well, it is snowing pretty heavily. At one point, Sergeant said it was near whiteout conditions. I don't know if I would agree to that, but it was coming down. But the snow's coming it seemed pretty straight down. It didn't seem to be particularly windy. And he's out there in what looks like a Harley Davidson hoodie, walking around in the snow for a significant period of time. You also see one still shot where Higgins has his cell phone up to his face and the screen is clearly brightly lit. So in some of the shots, you can see kind of a gesture towards his face. But then in one of those stills, you can very clearly see a phone to his face with a bright screen. Can this officer testify that that's a phone call? No. Could he be voice texting something? I mean, sure. But I think we will see other evidence establishing what was going on with phones at that time, again, from other evidence. So does it really matter ultimately? The jury has seen the phone to the face with the screen on. But is it fair that this witness is like, he's on the phone, but I don't see if he's on a call or not? Sure. But we will see information about that at some point later. It will have to get all tied together. So all in all, we got a lot into the Brian Higgins of it all and his motions around Canton PD. And wow, those videos are much more clear than any of the other videos we've seen out of Canton PD. Is it just me? Or were those videos pretty clear and easy to see? So for everyone who keeps asking about the Brian Higgins butt dials, this trial's not there yet, but we got into a lot of areas of cross, including a report, and I think this came in the first trial, a report from Proctor about accessing the Ring app and Ring videos on John O'Keefe's phone after they took John O'Keefe's phone into custody. You heard me correctly, not accessing a forensic download of John O'Keefe's phone. No. Accessing the Ring video app and Ring videos on John O'Keefe's phone. And I think we're going to hear more about that from the defense as they get into their case in chief. We'll see when and if Higgins gets called. That's going to be a real interesting strategic conversation. Like, if you're the defense, do you leave it alone? Do you not let Higgins come in and explain? Do you leave it and say, look, they never investigated Higgins. Look at all this behavior. I think if you're the defense, you wait and make that decision at the end of the Commonwealth's case to see how much comes in, because giving Higgins the opportunity to explain might be something the defense doesn't want to do. They might want to push it back on, and the Commonwealth never called him, and they never investigated him, and he's got a plow, and he's driving around doing all of this stuff, and you just leave it for argument, and you bring it in and closing arguments and say, and then there's this, and then there's this, and then there's this. They never even got his phone. They let him just hand over those texts. I think it depends how much comes in during other witnesses, and then make that decision and keep it in mind that maybe not calling him and letting him explain is the right call, and just looking at the jury going, and they never investigated all of this. Isn't that odd? Don't you wonder what they chose not to investigate? What is he getting from that truck? Don't let him explain what it is. What is he getting from that truck? weird. It's snowing. It's 1:30 in the morning, and he's walking all over that parking lot at Canton PD. The jury doesn't know how many drinks he's had yet. But after being out at the bar, and they never even ask about it. Isn't that odd? Shouldn't that have been investigated? But the prosecution might now be forced to call Higgins to let him explain. But then if the prosecution chooses to call Higgins, then you can impeach Higgins on all the things he said in other proceedings and what he said about his phone calls or lack thereof. If the timing is different between when Higgins is saying he got home and when video shows that he's not home, then that all comes up in cross-examination. So does the prosecution choose to run down that Higgins side quest, or do they leave it? We're going to get into a game of chess with what the Commonwealth chooses to do and chooses not to do. And I'm interested to see if they just stay the course or if these cross-examinations force the Commonwealth to shift what they do to respond to some of these cross-examinations that leave, I think, at minimum, a ton of questions in the mind of the jury. And that's what they're supposed to do. Will the Commonwealth be able to close those gaps or not? We're going to have to wait and see, because what we still haven't seen on day 14 is how John O'Keefe died, how the Commonwealth thinks that happened, when the Commonwealth thinks that happened, and the experts that back up that theory of the case. And it's day by day becoming more noticeable that that is not in yet.
On February 8, 2022, about statements made by the defendant to him.
Yes.
And could you share with us what the statements were as related by Mr. Whitley back on February 8, 2022?
The statement was,
Objection, Your Honor. Again, jurors, this is an offer for the truth that's contained in the statement, simply to show that this information is provided to the police.
the defendant made a statement questioning whether Mr. O'Keefe was still alive.
And anything about the nature of their disagreement?
Is that the answer that the prosecution was expecting? Not only did the prosecutor say, did Karen Read tell Daniel Whitley something about her having a fight with John O'Keefe the night before? Then he said, would it refresh your recollection to exactly what was said to Daniel Whitley by Miss Read about whether or not she and John O'Keefe had a fight the night before? And then he gives him the report, and then he's refreshed his recollection, and then they come back with Karen Read was asking if John O'Keefe was still alive. How are you not following the line of questioning on direct examination? I might have to rethink if he was just being difficult during some of the cross.
And you shared with us that he provided you a number of text messages between him and the defendant.
Yes.
You began to explain that you vet information during your investigation.
Yes, we do.
What did you tell him you were going to do with the messages he was giving you?
I explained to Mr. Higgins that we have in our custody and will eventually get into both the defendant's phone and Mr. O'Keefe's phone, so that protect his integrity as a law enforcement official. I told him that the information he was providing better be true and accurate, or else he would suffer the consequences of the ulterior.
I'm surprised that they didn't get into this more on cross. I think the defense was going to keep it and argue it. I told Higgins that if you are giving us texts, that we are going to have the other side of those conversations. So you better be sure that they're going to match. It's the wildest thing that Brennan is asking this question again. The answer was so bad the first time, and then Jackson didn't follow up on it. Why are we following up on this again? Does Brennan think this is a good look? He can't. We told Higgins, protect your integrity, bruh. Give us the text messages and make sure they're going to match.
Did you, in your mind,
Brennan walked this witness right into
having read
this.
those texts, find a motive for Brian Higgins to perhaps want to confront John O'Keefe because of jealousy?
If you're asking for my opinion is that he would need to confront Mr. O'Keefe. Mr. O'Keefe was not the one pursuing Mr. Higgins. It was your client that was pursuing Mr. Higgins.
Okay, so, well...
Unless, perhaps, because you said on cross like 700 days ago that John O'Keefe and Higgins were buddies. So unless John O'Keefe wasn't pursuing him, but do you know that John O'Keefe didn't say to him, yo, fucker, why are you texting back? I thought we were friends.
And then seeing him walk in the door with John O'Keefe and sending the text message after having been intoxicated. You see that, detective, as an investigator, as a reasonable, objective investigator, as a possible scenario for Brian Higgins to be jealous about John O'Keefe.
There's a possibility there, but I didn't see it.
Did you explore that possibility?
Right.
When you got all these text messages?
We did not follow up on that
That's exactly the
aspect
point.
based on the totality of the entire investigation.
Did you pull the tape at the waterfall and review the tape as we did here in court?
That is the defense's entire argument, isn't it? There's a possibility there, but we did not follow up on it based on the totality of the evidence. Isn't that the defense's argument? There's a possibility there, but you didn't follow up.
At the time, you didn't pull the tape at CPD that we saw with Brian Higgins on the phone at 1:30 in the morning, correct? You didn't have that information.
I'm sorry, can you
time-
give me a reference when
Sure.
at the time?
At the beginning of your investigation, January 29th and probably the next, let's call it a couple months.
Mm-hmm.
You did not have that information, correct?
No, we did not.
And you didn't seek that information from CPD at that time.
No, I had no information that he went there.
Okay?
What?
And you didn't extract his phone, correct?
That's correct.
It looks like at the end of day 14, Sergeant Buchanan is done with his testimony. It has been a number of days of Sergeant Buchanan's testimony with a lot of information. And while Attorney Brennan, I think, really tried to do some damage control on redirect, I don't know how much damage was controlled. I think one of the stronger lines of questioning during redirect was, does Trooper Buchanan know any of the people involved in this case? He doesn't. But is that going to be undermined if we get into testimony of everyone that Trooper Proctor knows? I don't know if it will help. And beyond all imagination to me, and I don't know if I'll be able to tell you tomorrow either, we saw Attorney Brennan ask Sergeant Buchanan again what Brian Higgins was told when he gave over, I can't say extracted because it wasn't, when he gave over the text messages between himself and John O'Keefe and himself and Karen Read. And again, Sergeant Buchanan said, in sum, I told him we had John O'Keefe's phone and we will have an extraction from Karen Read's phone. So to preserve your integrity as a police officer, they better match. Is that a helpful answer to the Commonwealth, or does it play right into the defense's theory that there were avenues of this investigation that weren't followed up on? Because I can see a world where the defense argues, see, they didn't even do a phone extraction of Brian Higgins. They just said, hey, give us those texts. And just know that we're going to have the other side of those conversations. So if anything looks wrong, well, then you're going to suffer the consequences. It's a wild thing that the Commonwealth elicited that answer again, thinking that it helped. And there were times when the Commonwealth was trying to give this sergeant room to explain all of the evidence that they considered in their investigation, and he kept needing his memory refreshed. So to rebut the defense's, hey, these are all the things the investigation didn't look at, The prosecution on redirect was trying to get into the weight of the evidence pointed in one direction. I think that's a bit undermined when you are using the sergeant to go through it and he doesn't remember what the weight of the evidence is. He just kept saying the weight of the evidence. Okay, the weight of the evidence, what? The statements from Nuttall? I need my report to look at the statements from Nuttall. Okay, what about the statements Karen Read made to the other paramedic when she was being taken to the hospital? I would need to refresh my recollection from that report. What about your interview with Katie McLaughlin? No, I would need to refresh my recollection. So instead of being able to list out the totality of the evidence, he just said the totality of the evidence repeatedly. And I don't think he well explained all of the evidence that he knew that was leading them to believe that there were no other avenues for investigation. And I think the defense did a better job of pointing out all of the things that were there with Higgins. So you never extracted his phone. You didn't look at the video from the waterfall. You didn't look at his text with Karen Read to think that that might cause some kind of an issue between Higgins and John O'Keefe because Higgins is texting his girl. You didn't think that that might cause a problem or that Higgins might want to confront John O'Keefe? And he was like, well, no, John O'Keefe's not the one pursuing Higgins. I'm not even exaggerating. That was his answer. You didn't pull the video from Higgins walking around Canton PD that we saw quite thoroughly earlier today. And he said, no, I didn't know he went there. You didn't know that Higgins went from 34 Fairview to Canton PD at 1:30 in the morning when he was, by all accounts, like a bottle of Jameson deep? That might be an exaggeration on my part. He had a lot to drink. And because Higgins has not testified yet, I think the defense made a lot of ground with, isn't it a reasonable interpretation that these things could have happened? And Sergeant Buchanan agreed with the defense a number of times. Yes, I guess it could be interpreted that way. Yes, I could see how you could interpret it that way. Yeah, that's a reasonable interpretation of that. That's not how we saw it. But they didn't follow up that investigation. Even when Brennan tried to bring up better points during redirect. And then, surprise, surprise, the defense had brought up all of the pieces of taillight that Trooper Proctor collected. And photos of them and photos of the bags. This name is Proctor. This is the handwriting that matches that other handwriting. He was by himself. And the prosecution moved those all into evidence without objection with Sergeant Buchanan after the defense brought them up on cross. So now we have all of those pieces in evidence as well. So if the Commonwealth chooses not to call Proctor, they don't have to. Everything that Proctor collected at this point, at least all the pieces of taillights, are now in evidence. Though a long day with Sergeant Buchanan on the stand, it seems to indicate that both sides are anticipating a world where the Commonwealth does not call Trooper Proctor. And at the end of the day, because I had a chance at the break to take a look at what was filed before court started today, the motions that I saw is the Commonwealth's motion to preclude inadmissible hearsay under the guise of the Bowden defense. The defense got into a lot of hearsay with regard to Bowden defense. And then the Commonwealth was allowed to get into it too on their redirect into things that this trooper was told. The Bowden defense, again, being the defense that other avenues weren't investigated. And I think the defense has very much started to vet that out, that other avenues weren't investigated. Then we had a Commonwealth motion to introduce additional evidence of the nature of the defendant and victim's relationship. Quote, 4 weeks prior to the murder, the defendant became enraged at the victim for speaking to a female friend who was on their group vacation in Aruba and accused the victim of having an affair. So it seems that the Commonwealth has, as of this morning, made that motion to bring in the information from Aruba. Has the court ruled on that? No. Do I think it'll come in at this point? Yes. I think Aruba at this point will likely come in. And then we saw the defendant's opposition to the Commonwealth's motion to preclude inadmissible hearsay under the guise of the Bowden defense. And we saw a lot of objections from the defense about that today. It looks like what went down in Aruba is going to come in after the cross-examination of Sergeant Buchanan. And I think the court will allow it. Will it help the Commonwealth much? I don't know. The jury has to be sitting there wondering how in the world John O'Keefe was killed at this point. But the impression that was left, or at least one of the impressions that was left, was from the text between Karen Read and Brian Higgins, that Karen Read believed that John O'Keefe cheated on her. And I think the Commonwealth wants to present what they might see as the other side of that, which is this was a overreaction to a more innocent situation. I think that's why the Commonwealth would want to bring this in. So saying, hey, in the text messages, she is stating that they hooked up, though in some of those text messages, Karen Read does say that John O'Keefe was absolutely hammered, so she doesn't think they actually hooked up, but she still thought that they had hooked up. So I think we're going to see that testimony come in part to show the Commonwealth's side of those text messages. So it looks like we're going to get into Aruba because they did talk about New Year's. Will it be a nothing burger for the Commonwealth? I think the Commonwealth runs the risk of focusing on all these side avenues before they show the jury what happened to John O'Keefe. Because now we're running down who perceived what and when. And Karen thought that he cheated. And did he not? Was it a big reaction? Was it not a big reaction? Was everybody drinking? Yes. Does it help? And do they need to run down that avenue to show that Karen Read had a large reaction to John in Aruba during New Year's? I don't know. I think it's already in evidence. And again, they've heard her voicemails. So I think there's an argument that she had a very big reaction to him on New Year's and everybody was still alive. So did she blow up at him? Yeah. Did she blow up at him over voicemail? Yeah. Does that prove that John O'Keefe was hit by a car? No. It proves that that's consistent behavior. Okay. So if it's consistent behavior, is it out of the norm for them? Probably not. They were drinking and then they got upset and there was yelling. Does that seem consistent from what we've seen? I think so. Will the jury see that big reaction as like one big reaction too many? I don't know, because I think the jury's going to really want to know what the coroner has to say about how John O'Keefe died before they make a decision based on voicemails. Because I imagine that the jurors are going to sit there being like, okay, so where's the rest of it though? How did this happen? And then they might have more context for everything else. But right now they're being given context that they have not a lot of framing for because they don't know what happened to John O'Keefe and how. So will leaving the scientific experts to the end be a problem? It might. We're going to have to see. I hope that we see that soon. We'll see what day 15 brings when we go back to court tomorrow, which means it's the perfect time for me to remind you to get the Law Nerd app so that you know when things happen in court. The jury now has seen, as of today, the Sallyport video of Karen Read's car arriving at Canton PD, Karen Read's car in the Sallyport, both inverted and non-inverted or mirrored and non-mirrored with timestamps. They saw that horribly janky, unwell camera that you can barely see anything on. And I don't think they ever played it again when they were trying to get it to play. I don't think they ever got back to it. We saw all of the very clear cameras that show presumably Brian Higgins getting out of his own SUV and walking around Canton PD. I don't think there's much of an argument that it's not Brian Higgins, but that video's so much clearer. One of the cameras outside the Sallyport wasn't, but the other ones were very clear. So we finally have the Sallyport video after 14 days. Let's see how many days till we get to a cause of death. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.